See anybody raising their hands? So I'd like to call to order the Committee of the Whole for the Urbana City Council. Could I have a roll call, please?
Councilmember Wu?
Here.
Councilmember Evans?
Here.
Councilmember Hersey?
Here.
Councilmember Colasetti? Councilmember Bishop? Councilmember Wilkin?
Here.
Councilmember Quisenberry?
Here.
Mayor Williams?
Here.
Thanks.
All right, first item of business is we have several meeting minutes to approve. We have the November 3rd Committee of the Whole meeting minutes, the November 10th City Council meeting minutes, and the November 10th Special Committee of the Whole meeting minutes. Could I have a motion to approve those three?
So moved. Second.
All right, it's been moved and seconded. Is there any discussion or substantive changes to those minutes that need to be called out?
Yes, so I just do want to call out that I believe it's for the November 3rd Committee of the Whole minutes. Councilmember Wilkin was actually participating via phone, and that wasn't denoted on the first page, so I'll make that correction before they're published, but I am aware of it.
All right, thank you. So seeing, is there another issue to raise? Okay, all right. Seeing no further discussion, I would ask for an approval of the amendments or of the minutes with the one change noted by the clerk. Would everyone say aye to approve those?
Aye.
Aye.
Anybody who disapproves, say nay. Okay, that passes unanimously. Are there any changes to the agenda as it has been presented, other than the fact that I'm leading this, other than Mary Alice? All right. Seeing none, we are now open again for presentations and public input. Would any member of the public like to address the City Council? Please come to the microphone and state your name.
My name is Karen Medina. I live in Champaign, but I spend an awful lot of time in Urbana. I just wanted to really commend all the work that has gone on for the item H. It is just beautiful, and that's ordinance 2024-12-042. A lot of work has gone on, and I saw it earlier, and I've checked on it frequently, but I just want a lot of research, a lot of work, and I hope you guys support it because it's good. That's all.
Thank you. Would anybody else like to address the Urbana City Council Committee of the Whole? All right, did we have any email to read out tonight? Okay. And we have no other presentations, so I'm going to close public input. Do we have any additional staff reports? Staff? Okay. First item of business is, under F, is ordinance number 2025-11-034, an ordinance revising the annual budget ordinance, budget amendment number 3B, the FEMA Assistance to Firefighters Grant. And do we have someone from staff providing some updates for us? Our newly minted fire chief.
Good evening, everybody. Thank you for having a little bit more conversation on this. We just wanted to be available and answer any questions. Our true goal in this whole process, our true goal, of course, is always to bring alternative funding and help support the city, help support the fire department as well, budget as well. But tonight is just simply to try to help answer any questions. We want to make sure that we're providing informed information, so when you do go and make this decision on how to move forward with this specific grant, we can provide you the best information as possible. Some of the information that we had provided when we had spoke on the last meeting, there was a little bit of information that we just didn't have all of the details that we would have liked, so we want to just make sure that we open up to all of you and answer any questions that you might have.
Yes, Mary Alice.
This may or may not be a question for you guys. We did receive a memo from, John's not here today. I know it was a different grant. I just wanted to know if, so basically it had to do with some of the federal stipulations within that grant and the courts finding all of them null and void. And so I wanted to know if that also would impact this grant, because I believe that was the majority of the reason why council members were not in support.
Mm-hmm. And that's one of them that we actually, when we brought this forward in October, that was one of the things that was reviewed by legal, and we wanted to make sure that we went through that process early on. Illinois versus FEMA was one of the court cases that specifically is tied to AFG and Department of Homeland Security, that basically says that they issued a permanent injunction. Am I saying that right? Permanent injunction that basically says that was unconstitutional, and basically they can't do it. So yes, essentially that's, from my understanding, what Illinois versus FEMA says. If you can expand on that anymore.
Can we get comment on that from legal counsel, please? Because what I want to understand you saying is that the concern about compliance with immigration and ICE and such that was causing people pause to support this is not currently legally enforceable. That's what I'm hearing.
So I'm not familiar with the specific case that DC Doggett is referencing. When I reviewed this initially, my understanding was based upon a separate federal case that was a more recent, wherein the federal court had issued an injunctive order prohibiting this federal agency from enforcing specifically the immigration compliance and cooperation communication related provisions of these grant agreements. While the actual substance of the case was pending in front of the court, which it still is, the injunctive order is still in effect. But more to the point, the practical effect of that order was that FEMA has essentially made that language null and void voluntarily by inserting a provision in its own agreement that says this does not apply to this particular grant. So that's what the memo analyzed back in November, I think it was. So.
I see a hand up.
I just wanted to speak to a letter that Public Works received from the U.S. Department of Transportation. We're going to speak to this in a manner here in a few minutes. But according to that the U.S. District Court has ruled that the U.S. Department of Transportation that the immigration enforcement condition has been deemed unlawful and ordered vacated from the grant agreements. So that just speaks specifically for a court decision as it pertains to the Department of Transportation. But I'm assuming the same case is being held with FEMA and the federal grants in that regard too.
Go ahead, Mary Alice.
So I just want to be 100% clear that I understand. This particular grant is for radios. It is one and done, meaning you buy the radios. Have they been bought, the radios?
They have not yet.
Okay,
No.
so we buy the radios and we submit reimbursement based on this grant, and then the actual grant application is complete. And so my question is, can they come back? Let's say that the injunction is lifted and we've already gotten the funds, and maybe this is a question for Matt. Can the federal government come back and say, well, they lifted that, and so now you have to comply?
To the best of my knowledge, no. I mean, that is the specific purpose of the injunctive order is to allow these funds to flow and be administered as usual during the pendency of the case. So any substantive change in the application of federal agency contractual provisions that are brand new like this would take effect prospectively.
And not
As a
retrospectively.
general proposition, yeah, that's how I understand that the function, and I think that's how it will function.
Okay, so my next question is, say this is approved, how quickly can the radios be purchased, and how fast is the turnaround from the federal government?
So the radios themselves can be purchased immediately because this is the radios are on state bid. So we don't have to go through a purchasing policy at that point in time. We can order them essentially as soon as it's approved. By the time that they come in, we close out the grant, and it's really dependent upon how fast the radios get here from the company.
Okay, and is there any estimate perhaps by finance in terms of how quick the turnaround is from the feds? And part of this has to be a timing issue, and where we are right now in the environment we are right now, and then how long that environment's going to last.
Yeah, I mean, the turnaround time, it can vary quite a bit. In fact, it's varied since January quite a bit. It's slowed down and sped up again, so it's hard to say. I would think not more than 90 days.
Okay,
Hopefully more like 2 weeks.
it's a big range. Okay, thank you.
Yes, Sharice?
Is it still one of the kind of situation that if we do not move forward with this and vote for it, that the city of Urbana will not be able to, probably not even be able or allowed or considered for another grant for our fire department, should we need something like that?
I'm glad you asked that question, because that's one of them that I had actually commented on in the last meeting, and I couldn't provide anything on paper. That is, in fact, true. What I said in the last meeting was that is something that we run into a risk of not being able to, or at least be impacted in the future. And that was based off of subject matter experts that we personally know, one being a consultant that we used to get one of our previous grants for staffing, which was the $1.4 million grant we received from FEMA. So that consultant had told us back then, if you're not going to accept this grant, which was the staffing grant, then don't apply for it. Just because of the impact. So another one was, again, a subject matter expert that we know that actually sits on the peer review panel and said very similar. The true concept in doing some research after the conversation we had at the last meeting was what happens when you decline an AFG grant. So this is directly from FEMA, but it says an applicant who declines to accept a grant during negotiation will not be penalized for declining the award. However, FEMA would consider that the grantee to be a poor performer if they accepted an award and subsequently returned it. So basically what that means is that if you accept it and return it, you're not physically impacted or penalized by declining that. You're impacted by being eligible or how you're rated in future grant applications. So in short on that, basically we aren't just impacted necessarily by turning down this grant, but what we would potentially get in the future of this. Just for a little bit of context here, this grant itself has been here since 2000. Urbana ourselves have been in a benefit of about $1.9 million that we can account for since 2011. And I couldn't find anything in between 2000 and 2011 that we might have gotten. So just as some context on that, we could potentially be impacted and labeled as a poor performer.
Okay, thank you very much.
All right, Mary Alice.
I'd make a motion if there's no more questions.
Grace.
Oh, I'm
has-
sorry.
There is question. My hand is up. My hand is up.
Okay, Grace is next.
Thank you. So you're saying there was a case with Illinois versus FEMA for not cooperating with federal agents?
Illinois versus FEMA was in September, and that was, I'm just gonna.
Because I haven't seen any of this. I don't know if you have information that hasn't been sent. I need to see any of that in writing.
Yeah, I can just send everything that I have on this, but it is a federal court case that granted summary judgment, issued the permanent injunction against the U.S. Department of Homeland Security, FEMA, ruling that the requiring states to cooperate with immigration enforcement in exchange for disaster relief emergency preparedness was arbitrary and capricious and exceeded Department of Homeland Security's authority.
Thank you. Yeah, if you could send
But
that.
I can send you that link if that would be helpful as well.
Yes, I need to see it.
Sure.
Thank you. And then, so I just wanted to clarify, so you said that we would not be penalized under FEMA for not accepting this, but we would potentially be flagged as a poor performer that could impact us down the road. But it is not penalized, and there's no guarantee that we would be impacted. It's
Yeah, that's
a possibility.
That's the definition off of FEMA's website. Was that an applicant that turns down the grant or declines the grant would not be penalized, however, is considered a poor performer. And then the other part of that that's important is based off of what we were talking about with subject matter experts that are involved in that process, say that is a deciding factor in whether you are chosen for the grant or not from the peer level.
And so we've already gone through some questions with the city attorney on some of the legally binding stuff on the contract. And so it seems like, yes, cooperating with federal agents is not relevant, not enforceable. Besides that thing, there's a article in this agreement that negates that because it's in contradiction to Illinois law. There are, however, provisions about following executive orders, and I believe the executive order prohibiting indoctrination in schools and no discriminatory equity ideology being allowed, which is absolutely against our equity and quality of life grants, our resolutions, again, about ending racial inequity, just against everything on the record for Urbana. So I would like clarification from city attorney on if that executive orders of indoctrination piece still stand.
Yeah, and I think what I said previously and what's in the memo is the language in the grant agreement does reference the specific executive order, and it was one of the first ones issued by the Trump administration in late January, and it relates to K through 12 education. That's kind of the subject matter of that specific executive order. It has language referring to what it calls discriminatory equity ideology, which is a sort of a term that they've come up with, including examples of what they consider discriminatory equity ideology. That is referenced in the grant agreement, the FEMA grant agreement. But the key language is that it prohibits, it refers to DEI programs, DEIA programs, discriminatory equity ideology driven initiatives. And I believe it also referenced immigration, but that's negated by the language that we referenced in the Article 58 of the agreement. But the key operative term in that provision is that it can't be done in violation of federal anti-discrimination law. Okay, so the legal standard is the same legal standard that has existed prior to this point. It does those terms don't change the legal standard, essentially. So they can say you can't do these things in a discriminatory manner. That's kind of the takeaway. It doesn't change what our legal obligation has been or would be moving forward. So that's kind of the takeaway. The rub is that it does not ultimately alter our legal requirements or any substantive obligation that we have.
Just a follow up on that.
Okay, keep going.
That seems subject to change, right? I mean, if there were a lawsuit that codified what discriminatory equity ideology meant and that it was enforceable, that could be the case. Seems like this is pretty uncertain. There's nothing to say that that won't be able to be enforced in the future. Is that correct?
To codify it, it would require Congress to approve new legislation as a new legal standard. The executive order functions as an internal directive to the federal agencies in how they administer their particular subject matter areas and the funding that they oversee. And so it's not a legal standard.
Okay. And then the other piece that does, without question, impact Urbana here potentially is a ban on divestment from certain countries of origin. Is that correct?
Not exactly. So as we talked about it, and let me find the exact language here. There is language in, I believe it's Article 19 of the agreement.
Yeah, you have A2 in the memo that you
So
sent to us.
it references what's called a discriminatory prohibited boycott without defining what that is or specifying examples of what a discriminatory prohibited boycott would be. And I think when we looked at this originally, we saw earlier iterations of this same grant agreement from the spring of this year, where that same language was used in conjunction with references to essentially boycott or divestment of Israeli-owned companies, right? With that specific type of action or initiative in mind with regard to discriminatory prohibited boycott. They then since removed any reference to those specific types of actions, and they just left the term discriminatory prohibited boycott in the agreement. They have since removed it entirely from new grant agreements moving forward. The new versions that you'll find on FEMA's websites don't even include that. They have also, looking back, was able to find some articles discussing the fact that they have not been able to enforce the earlier iteration of this language referring to divestment from Israeli-owned companies. And so it's been a sort of a changing landscape for FEMA in this regard. I can't say with absolute certainty that they wouldn't attempt to enforce something like that and apply, their earlier interpretation of it. It seems as if they're sort of distancing themselves from enforcing that language or including it in their agreements, now and moving forward. So, again, there's no absolute answer I can provide to say they would never attempt to enforce something like this. But what the city ultimately has to do is certify that it isn't doing this and hasn't done it, and won't during the term of the grant agreement, essentially. So what that actually means that we won't do is, I think, up for debate and discussion, considering the lack of any definition of the term. So,
Thank you.
All right, Chris, you're up next.
Thank you. So in all the grants that the fire department has accepted since 2000, was there ever conditions placed on the grants that suggested that you're going to cooperate with ICE in apprehending people and you're going to stop diversity, inclusion, and equity programming in your city? Was that ever part of any previous grant?
So that's a great question. Thank you, Chris. Good evening. From my knowledge, and of course I haven't applied for any of those grants, this is a brand new language that's been dropped on AFG, but I think multiple federal grants. So we applied for this grant in December. This language actually showed up in March of 25, so December of 2024 is when we applied for this. Just to kind of put a context of when this grant period is, this is brand new language that came through in March of 2025. And this is the first time that I know of that this has ever been introduced in any grant language.
So my question is, what is the definition of a poor performer? Can we not reject grants for cause and good cause? I totally believe you that you've been taken by surprise, as we all have, by the new conditions placed inside these grants. But can we reject them for good cause? And does that not, you know what I'm saying? If we were to apply for future grants, federal grants in the future for the fire department, if they try to tell us we're a poor performer because we rejected a prior grant, can't we do that for good cause?
Again, another good question. Typically, a poor performer has more to do with departments that are applying for a grant and they don't have the matching funds. So, for example, if it's a 90-10 grant and they end up getting that grant and say, I just don't have the $10,000 to pay my portion of it, that's what a poor performer has been historically considered as, or similar situations like that. They haven't followed all of the rules of the grant. They bought things that are outside of what they actually proposed when they did the application. That's the best example that I can give. For your direct question, though, honestly, this is one of those where this is something that we've not seen, or at least I've seen from the fire service level when applying for grants. So I can't really answer that question very well for you.
Yeah, we're in new territory, no doubt about it. So my question here is for Matt, and goes back to Alderperson Wu's first question. Are these disqualifying the unconstitutionality of forcing municipalities to cooperate with ICE being ruled unconstitutional? And there's been what Mary Alice described as a permanent injunction. Is it possible that the federal government could appeal the decision?
So, forgive me, Chris, you were referencing something about the constitutionality of the agreement provisions. Let me answer the simpler question first, and then maybe we can revisit the first part. But as to the federal case involving FEMA in Illinois from September, the order in that case has been appealed. I believe is on appeal presently by the federal government. So the answer to that question is yes.
And that's why you keep saying pending, right? Everything's pending.
Correct.
Okay.
But
okay,
let me caveat that, Chris. Let me caveat that. So I think we're focusing too much on the status of the federal cases and not enough on the language of the contractual agreement when it comes to the immigration. That's a pretty simple answer. It's in the plain text that the immigration provisions do not apply to this grant. It's explicit in Article 58 of the grant agreement. So regardless of the status of the case on appeal or other cases that may impact whether the federal agency can enforce this language, it has voluntarily withdrawn applying this language related to the immigration coordination and cooperation. And so that I think we can set aside as a concern. If we enter into this agreement, that simply doesn't apply by the terms of the agreement itself.
Why, Matt, did they leave in the DEI and the ICE cooperation articles anyway with Article 58? Why the contradictory language? Why did they leave in Article 11 and Article 19 then?
I can't speculate as to what they're thinking or the rationale is. I mean, I had thoughts in reading through it. It's confusing, particularly if you don't read the entire grant agreement. You're left with one impression until you get to the second to last article of the agreement. That in and of itself could be construed as one of the purposes.
Okay, I don't have any other questions. Thank you.
All right, Mary Alice.
I have one follow-up question. What is the last date that we would be able to accept the grant?
Another good question. So when we started this, we actually were on a timeline. So this was originally approved on October 21st, I believe it was, with an October 24th deadline. Because of the government shutdown, that was extended because the entire portal was shut down as well with the government. So that got pushed back to November, help me out, November 24th. Again, with government delays and everything else, they've pushed that back again. And that's why, again, we're here being able to offer a little bit more context into everything is because the final date that this got pushed back to is December 31st. So our deadline's been pushed back a couple times, and our current deadline is December 31st to accept it if we want to.
All right, Therese.
I just want to get some clarification, okay, for those of us sitting in the peanut gallery. Matt, okay, number one, whatever this mess is, that the language in this thing, regardless, not only does it not apply to us, and correct me if I'm wrong, not only does it not apply, but even if the idiots in Washington manage to get this stuff passed, it is not retroactive. Is that correct?
In a nutshell, yes.
Thank you.
I could.
That's all, nutshell, that's all I need. I'm a peanut. I don't need nothing else but the nutshell. Okay, number two. If we, I know you guys can't give us definitive reasons why we would be poor performers, but I keep thinking something also comes to me, not just regarding how grants usually go. If we don't take the grant, that may be one of the reasons, and this might help answer Chris's question too, or at least give him something else to think about. One of the reasons why we would not be eligible on some level to get any other federal grants is that you deny it, well, you don't need the money. So you can apply all you want to for another grant, but hello, we tried to give you some money before. You don't need the money, okay? That may be another reason other than, not having the matching funds, so on and so forth. And Chris asked a very poignant question, which was, and one needs to speculate. I guess you weren't willing to speculate, Matthew, but I am. Chris, the question almost answers itself because it's one of those things where it's like, why would they put that in there? Well, one person wrote this stuff up. And hello, we're dealing with the DNA of mediocrity in Washington. So let's just you know the answer to that question without even asking it. So I just want to get some clarification that even if we take the grant, which I think we should, it's going to get spent. There's no way that they can retroactively say that anything about it, because right now everything that's in there is unconstitutional. It's and not only that, I think we put ourselves, these folks aren't going to be in power forever, and I think we put ourselves in a very precarious position of not being able to receive other grants if we deny this grant. And there's no guarantee that any of us are going to be here in the coming years regarding what may be needed for our firefighters, and there's no guarantee that those people will be in office in the years to come.
Sharice, do you have any other questions?
I just want to make sure that I understood that this is not going to be something that we'll have to deal with again, hopefully, except if we don't take the money.
All right. Are there other questions? Mary Alice?
I have a question of the chair. Would you be willing to take a straw poll of council if there is any information that could be provided or clarified that would allow this to have 6 votes?
Well, first thing I would say, it does not need to have 6 votes tonight, because this is committee of the whole. We could send it to council.
That's true.
So I do believe that your question is relevant, but it can be addressed next week at council. If my understanding is Grace wanted to get the information on the legal case that was referred to. I don't know if Chris had any other standing questions. The reality is that at council.
I do.
Oh, go ahead, Chris.
My question would be, James, what is the definition of a poor performer in accepting a grant? And the fire chief gave the definition of not having the matching funds. Alderperson Hersey has added the idea that the federal government could say you don't need the money somehow. And my question further is, can you deny grants for just cause? Like, you have a reason why you're not accepting the grant, other than we don't have matching funds, which we do.
Okay, so Chris, you would like further explanation on whether you can escape the poor performer label if you reject with cause? Is that am I understanding that correctly?
Good paraphrasing. Yes, that's what
Okay.
I want to ask. Yes.
And so those are the 2 items that I'm hearing, Mary Alice, that are to be resolved and could put us in a position next week that we could vote on this and potentially pass it. Go ahead, Mary Alice.
So I'll make a motion if there's no further questions. I'll move that we send to City Council for approval ordinance number 2025-11034, an ordinance revising the annual budget ordinance, budget amendment number 3B for FEMA assistance to firefighters grant.
Second.
On the regular agenda, right?
On the regular agenda.
All right, seconded by Sharice. Discussion. Grace.
Thank you. I'll just say that, in my opinion, this is not about the radios, and it's not about the money for them, that we have the money for them. We just saw in the forecast, we have funds available. I would definitely be in favor of using for the radios. I think that's an important thing. It's about the agreement with Homeland Security. I still have concerns. I will appreciate some more information, but I still have concerns about the equity and divestment bans. And just want to point out that things are very different now. And I think we're going to have to check the grant agreements in fine print in all of them. The fact that we have the Department of Transportation trying to get us to enforce immigration to get money for our roads, that the fire department is having to agree with this. I think we are going to have to read all of these agreements with the federal government extremely carefully, especially from the Department of Homeland Security. I'm just not okay with this, and I think it's about way more than radios. For me, it's not worth selling our Urbana values and potentially putting us at risk for something that we can't otherwise meet. We have money in reserves for federal grants, I thought was for these types of purposes. If it's only for we don't get the money, or are we willing to say that we will not accept funds under these conditions? So I guess I'm not sure the direction of a city where we stand, but I do not want to go down the path personally where we are agreeing to a lot of things under the federal government for accepting federal grants. And this has a lot of red flags for me still.
All right, thank you. Other discussion, Mary Alice.
Yeah, so I've kind of taken some notes here. I feel like the poor performer question that Chris has had would calculate in the rating of a specific grant. And so when a grant is reviewed by an agency, they give points as they score a grant application. And if you are a poor performer, then you would have a lower score for that particular category. That's how I interpret it. I fully agree that a lot of the stipulations within this grant do not represent the values of Urbana. So I completely agree with that. If we look at the particulars in terms of how is it enforced and how does it apply? So if I look at that, and we're talking about the indoctrination is K through 12. We're not the school district. So in my opinion, that doesn't apply to the city of Urbana. Is it right? No. But does it apply in this situation? No. Specifically in regards to operating with ICE, which is in contradiction to our sanctuary city status, it does not apply very clearly. The notification, or rather the assumption, the agreement for disinvestment, however we decide to define that, however we interpret that at the federal level, we don't have anything on our docket that would address that. In my opinion, it would not get passed within 90 days, which is the outside time frame that has been offered to us in terms of a time frame we would be reimbursed by the federal government, given if we have an actual budget at the federal level. And last but not least, speaking to DEI, I think fundamentally what all of our ordinances say is that we do not support discrimination based on many characteristics an individual may have. That to me is not in contradiction. We do not support discrimination based on any of those categories. I feel like we are in compliance with the federal law there. So for these various reasons, I think that, and I feel that we can accept this even though we do not agree with how certain things are phrased, because I don't think it's relevant to the city of Urbana at this time frame, given the length of the grant.
Thank you. Any other comments? Chris?
No.
Mary Alice, can you take the chair?
I will take the chair, and the chair recognizes James.
Yeah, I want to reiterate the point-by-point discussion that Mary Alice has just gone through with regard to this particular grant. I want to remind everyone that this is our money. This is money that citizens have paid to the federal government. And if we allow things like this, which cannot be enforced, which do not apply to our area, to prevent us from proceeding with this, if we had passed this when it first came to City Council, we would have the reimbursement and we would be done and we would not be subject to retroactive enforcement of these things. We have no intention of committing to the items that don't apply to us, and we know that the items that we're most concerned about are irrelevant by the grant agreement itself. That's the way I understand it. So I think we are doing a disservice to the taxpayers of Urbana who pay federal taxes, who are funding this monster. If we say we're not going to participate in this when we know we can do it without stepping on our values, without backing off of where we are right now, then my feeling is they're winning, and I don't want to let them win in that way. I think we should move forward with this, and that's why I'm going to vote for it.
Would you like the chair back?
I would.
I will relinquish the chair.
All right, thank you. Any further discussion? Grace?
Just wanted to, on some of that point, if we could have clarification for, if we're having clarification for a future date on Article 56 and termination with failure to comply with the terms and conditions, and if we could have clarification on what that would look like if we did accept it and we failed with the terms, either before, after, or during that 90-day reimbursement window.
All right, thank you. Mr. Mayor, do you have any comments on this before we move on? All right. So where we are right now is we have a motion to send it to City Council for regular consideration on the regular agenda for approval. And so I will ask for a voice vote because this is not final action. So all those in favor say aye.
Aye.
Any opposed say nay.
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 Okay, that passes 3-2 because I voted aye. All right, we're going to move on to the next, to new business. First thing, thank you, gentlemen. First thing up is ordinance number 2025-12-035, an ordinance authorizing the purchase of certain real estate, 2302 Vance Road, Urbana, Illinois.
Good evening, council members. I'm here to answer questions. I have no presentation at this time.
You might want to just give a summary for the public.
Certainly. So tonight we are considering an ordinance for the purchase of real property at 2302 Vance Road, Urbana, Illinois, which is the property north of the interchange on Cunningham Avenue. And the ordinance in front of the council tonight is to approve the purchase and sale agreement, which is in draft form and attached to the memo and ordinance. No material changes would be made to the purchase and sale agreement if it were to be accepted, recommendation to move it to council to accept, but the purchase and sale agreement is attached.
All right, thank you. Any questions? Mary Alice?
I don't have any other questions. I wanted to clarify for the public that this would be using TIF 4 funds.
That's correct, yes.
And it's approximately just under $1 million?
That's correct. The total purchase or the total purchase price would be $915,000. In our ordinance, we've recommended that the purchase not exceed $925,000. That additional $10,000 would be reserved and encumbered for the purpose of the 50-50. It's a little complicated. Essentially for the maintenance of the property before it is repositioned for redevelopment. So there is a farm lease agreement included in your packet. That farm lease agreement, it has been in place with the owner for the current owner for I think 30 years. And so instead of the city becoming responsible for the maintenance of the property if we were to take ownership of it, we would honor that existing farm lease agreement, and the farmer would stay in place and continue maintaining the property, farming the property for that duration of time where we are crafting an RFP, posting an RFP, waiting for a redevelopment agreement to move forward. So the $10,000 on top of the $915,000 is to have funds available to move forward with that lease, that farm lease.
And then the other two pieces of information, this is a property that is north of 74 and east of Cunningham. Is that correct?
That's correct.
Okay, it's right there. And my final question, this is an actual question, is the phrase encumbered on TIF 4 because we're closing it out? I'm not sure exactly, because we won't close this month if this gets approved.
So I think I may have been using the term encumbered incorrectly. Basically, we would be, it's like opening a purchase order for this purpose, but the funds will be leaving the TIF 4 account before the December 31st deadline if we were to move forward with this agreement.
So it does allow us to move the funds that would cover the agreement before the close of TIF 4.
I guess it allows us to reserve the funds with the purchase order, and that's why I've been using the term encumbered. But Elizabeth can clarify if that. But essentially, yes, it reserves or locks in those funds before the December 31st deadline for these purposes.
Okay, thank you.
Elizabeth,
My
what
hand
term
is up, Mr. Chair.
Just a second. What term would you want us to use, Elizabeth?
I mean, I don't think encumbered is wrong. Once we have a commitment, we will encumber the funds. So as long as we have that commitment by December 31st when the TIF closes, we'll hold on to those encumbered funds for that purpose.
Okay, thank you. Go ahead, Chris.
Thank you. Olivia, again, for the public, does the city currently have signed contracts or commitments from a hotel motel business or a truck stop business to develop on the Pickerel property?
No, sir, there are no current contracts in place for hotel or truck stop.
My second question is, will the city require that employees of any future hotel, motel, or truck stop be 80% Urbana residents?
Chris, I'm not sure how that question can be asked since there is no contract or plan at this point.
Do we have a plan to do that? Can I ask that?
I think that's a really valuable question for discussion. At this current point in time, there's actually no real plan in place for how we would structure the RFP. We haven't spent the staff time or dedicated the staff time to crafting the RFP, and that's a very involved process that requires that would certainly we welcome the input, but at this point in time, we do not have a plan in place to do that.
Thank you. Let me ask it this way, Mr. Chair. Is it a possibility that the city could require employees of any future hotel, motel, or truck stop be 20% African American? Is it a possibility
I don't
that
think
we could
so.
put that requirement
I
on?
actually don't think so. I'll let the city attorney respond. But I don't believe we can make qualifications based on race for hiring. That's just my gut reaction. I'm not an expert in that space, though.
Yeah, I mean, off the top of my head, based upon what I heard, I do not believe that would be a legal constitutional requirement under a development agreement.
Okay, I mean, it's a fuzzy area, right? Affirmative hiring and affirmative, accepting applications, affirmative letting people into schools has always gone back and forth. I understand that. One last question, Olivia, and I appreciate your patience. Is it a possibility, again, just a possibility, that the city could require that employees working at any future hotel, motel, or truck stop earn a wage that affords rent in the city of Urbana? Is it a possibility?
Thank you, Councilmember Evans, for these questions. You're stretching my my technical skill here. At this point in time, I'm unable to answer that question. I don't want to be misleading for yourself or the public. So I would urge you. I would welcome more discussion on the crafting of the RFP if we choose to move forward with this purchase and sale, given the timeline. And then when we move forward into the development of the RFP, I certainly would welcome this level of discussion and these questions. At this point, I'm unable to answer that.
Is that all, Chris?
Yeah, thank you for everybody's patience. I appreciate it. Thank you. No further questions.
Matt, did you have something to add to that last question?
I was just going to say, I think that would require some significant additional research before we could answer
thank you.
one way or the other on that.
Grace.
Thank you. I think with that same line of thought, I would definitely like to know more about the RFP process before it's released. I think that would be great. And I think we have a lot of other questions to offer that will be helpful in that process, like how other businesses around would be impacted by bringing in duplicate business close to this area. So I would definitely have quite a few questions, and I think the community would as well. So I think whatever the most transparency we can have in that process would be great. And also, you mentioned in the memo a whole bunch of work that's been done by studies from RPC and other analysts. And I don't know if we could have any kind of summary or update on that relevant to RFP process.
Certainly. So those reports, let me just. In the memo, I referenced reports that had been produced in prior years, simply as potential resources to inform the RFP work and to illustrate that these properties have been in discussion for some time. Is your question about how they will inform the RFP specifically? I meant, my intent was simply to name them as resources around these properties that exist today.
I think if we could have the things, like I can probably, hopefully dig around the city website and find those, maybe not, but if you have those reports available in your review, if you could share the reports as you're going through the process, like if you use information from those to inform the RFP, I think that would be helpful to know. I understand not at that point yet, but when we get there and hopefully we have a discussion about that, those would be useful to know how you're using them and having the full reports themselves.
Okay, certainly. Thank you.
All right, any more questions? I do have a question I'm going to ask you, Olivia, but feel free to look around for people who have been here longer. Are you aware of any time the city has released an RFP for land that it controls that where the RFP was not discussed at council before it was released?
I don't think so. I'm not
looking
aware.
a little towards Mary Alice because she's been here as long as anybody. Yes, Mary Alice?
The two past RFPs that I'm aware of that have been passed was 200 Vine just north of us. That absolutely went through a process at City Council. And then, oh shoot, it just left me. There's another RFP that we went through.
One for the parking lot south of Lincoln Square.
We have the Illinois Street RFP. That's our most recent RFP. I believe that went through a public process as well, but
Yes.
I can't speak to that directly. Okay, good.
Absolutely.
So we don't have a background of RFPs going to the public without council having input that anybody's aware of. Okay, thank you. Grace?
I would need a reminder on what that process was for the RFPs for downtown properties. We've talking about that a lot. I don't know if they're out. I was actually wondering that in this discussion, but as far as my recollection or understanding, we did not have any meaningful input on that process. So if I could have some clarification on when we have, that would be helpful.
Yeah, the only one that's been released while I've been serving on council was the one for south of Illinois Street, the parking lot area. And I do recall the discussion at council about what area was involved and what the goals of that RFP were. I don't think we've done one for the land on Ray Street at this point in time. And that's the only other one that I know of that's been in play since I've served on council the last 4.5 years. Mary Alice?
Yeah, I just wanted to let council and the public know of the 200 Vine Street just north of us was actually 10 years in the making. And there was a very robust conversation both in internal meetings and in the public. And also, even before it was allocated to the individual who eventually got it, there was public meetings, there was input. City council members went and spoke to the developers. So it was a very involved process. Now, that's 200 Vine Street. That doesn't necessarily mean that we have that much of a process, but I thought it was a good process. I thought that we came up with a good compromise between what the developer had envisioned and what the community would have liked to see there. Not everybody got exactly what they wanted, but that says to me it was a good compromise. So hopefully that 200 Vine Street process that we did could be done again for something like this.
Thank you for answering my question. Any other questions before we have a motion? Chris, are we done?
No further questions.
All right, could I have a motion?
I'll make a motion.
Chair recognizes Mary Alice.
I will move on to City Council regular agenda. Ordinance number 2025-12035, an ordinance authorizing the purchase of certain real estate at 2302 Vance Road in Urbana, Illinois. To City Council for approval.
I'll second.
Seconded by Sharice. Discussion.
My hand is up, Mr.
Okay,
Chair.
Chris, you're first.
Thank you. There are some people in Urbana who struggle with affording assurance if they have insurance at all. There are some people in Urbana who struggle with affording their utilities. There are some people in Urbana who struggle with affording their gasoline. There are some people in Urbana who struggle with affording their rent. And there are some people in Urbana who struggle with affording their groceries. I often ride the MTD bus every week with many of these people. So for me to come in here tonight behind their backs after I put a knife in it and spend $915,000 of the Urbana taxpayers' money on corporate welfare for the hospitality industry and for the petroleum industry, two industries that have more money than God and who could easily afford to buy that land themselves, is both untenable and immoral, especially after I did the happy dance in front of the residents of the South Philo Road Business District, promising up and down, I'm going to do this and I'm going to do that I'm going to invest in local businesses, that I'm going to invest in local people, and that I'm going to invest in local infrastructure, and that I'm going to invest in an alternative response system to enhance public safety in order to create an economic and cultural renaissance in the South Philo Road Business District. But instead, I come in here tonight and engage in a socialist redistribution of wealth from the Urbana taxpayers to out-of-town wealthy elite corporate welfare queens who don't need the taxpayers' money, they just want it. To go along with the usual okie doke, squandering $915,000 of the taxpayers' money and a chance to invest that tax money to help local Urbana residents will probably get me kicked off the MTD bus, as it should be. Thanks for letting me speak.
Mary Alice.
So I'm going to respond to Chris's comment. So first of all, the funds that are being proposed for this have to be spent in that specific geographic area. So it's not as if we were able to take the $915,000 and invest it in Philo area. What this could do, and I think in some regards, Chris is correct. This is assistance to businesses. We don't know, however, what business. I can tell you that the 200 Vine Street was a local business. I don't know who owns hospitality, different areas, and gas and so forth. So that's not necessarily 100% incorrect. I can say that one of the purposes for TIF districts is to boost the economic development of those particular regions. And we heard from the budget officer that what's going to help us is economic development, which we can then take some of those monies and invest in Philo. And so economic development within the city, I think, will bolster some of the different projects that a lot of people are in support of here. But without economic development, we are facing hard decisions with the budget for all of the asks that people want to do. So I feel like because the money is geographically bound in TIF 4, because the money is being designated for hopefully economic development, and because we need more economic development to help areas like Philo, I am in support of this.
Thank you. Grace.
Thanks. I appreciate those points. Definitely see the aspects of them. I think that's, for me, the importance of needing to have that really thorough and involved RFP process. And I think we would really need to justify the actual benefits of the people to Urbana, whatever it is. If you want to be a hotel or a gas station, what would be the impacts environmentally and economically for that versus having a local, we talk about farmland in here as being underutilized, which there's plenty of issues with industrial, mass-produced, pesticide-ridden agriculture, but there are also other options, and that there's really importance of having local, sustainable food sources. So I think that, I'm in my mind, this is the first step of purchasing the property, and then the next step is, as you've highlighted, then what to do with it. And I will be much more critical in the sense of critical thinking and justifying this expense to the people when we come to that part of the process. And then I had a technical question, if we expected that we were going to meet again before December 31st.
Yes. So because the committee of the whole from December, the first originally, got rescheduled due to weather. It is happening tonight. And so ordinarily, December 15th would have just been a committee of the whole, but we are going to have a council meeting for the rescheduled committee of the whole items next week on December 15th. And as of right now, we do anticipate having a quorum, albeit by the hair on our chin. But we are planning to meet next week on the 15th, ideally in a council meeting and possibly also a committee of the whole.
Thank you.
All right. Other discussion. Mary Alice, would you take
My
the
hand
chair?
is up again.
Oh, go ahead, Chris.
Well, you haven't talked yet. Go ahead.
No, I'm the chair. I have to wait till last. Go ahead, Chris.
Okay. Just to respond, I want to remind that we have no contracts or commitments in place. There is no economic development. You're guessing, speculating, wishing, and hoping. As far as the RFP for Lincoln Square parking lot, it never happened. As far as we have yet to have anybody commit to the Vine Street where the adult education building is, we have no commitment there. We have no commitment to knock down the downtown jail. The the economic wishes and hopes are just that, thin air. There is you can't count on economic development happening north of I-74 when you don't have it yet. If you had something signed and a commitment, you might be able to count your chickens because they've already hatched. But as of yet, it's all a guessing game and a hoping game, and you're playing with their money, the taxpayers' money. Also, that $915,000 goes back into the next contiguous TIF district, which would be, I think, TIF District 3. And you're right, Mary Alice, it wouldn't directly go to South Philo Road because there is no TIF district out there, but it would go back into the coffers of the next TIF district, for which the taxpayers would have access to use that money for something else. Thank you for letting me talk.
Charisse, I saw your hand go up.
Am I incorrect in thinking that it would go into the central TIF? It would go into central TIF. Okay, so my other question is, and this basically, I don't know, Chris, I understand, I guess you're being upset about, I guess what I want to know is where is this information about a pilot or some kind of gas station trucker thing, where is that information coming from? Is that something that, yeah, can
it
you?
was in the memorandum.
Olivia, I'd just like to hear where it's coming from because I keep hearing about stuff that I'm not privy to or don't know anything about.
I'm going to allow this question, but we're in discussion. Go ahead, Olivia.
There are two studies that were referenced in the memo, one for hospitality and the other for I believe it's basically a truck stop. I think it's called a transfer station.
Mm-hmm.
We had, before there was a conditional offer letter signed by the current owner of the property, we had a closed door session where I highlighted some of the benefits, tax benefits to the district in terms of revenue from those businesses. The reason I've been highlighting commercial uses as potential revenue generating for this site is because this site is zoned as a commercial zone. So unless there was a rezoning in place, I'm operating in what's currently possible. So that is where I've highlighted in the past those two particular types of business. But it's kind of a blank slate, and we can move forward through the RFP process. However,
So there's nothing stating exactly what kind of business would go there, if a business was to go there, which, by the way, would, offer some employment for people and so on and so forth, correct?
There's nothing binding us to any given type of business except for the current zoning, which is, I'm not remembering the current, it's a business zone. I can look it up quickly, but yes, that's correct. There are no current parameters on the type of business there.
Okay.
I don't know the zoning.
All right. Mary Alice, would you take the chair?
I'll take the chair, and the chair recognizes James.
All right. I am going to vote to support this because the quickest way to have nothing happen is to do nothing. And letting it sit here idle. This was a hotel years ago, and that ownership failed to maintain it. It became an issue. It had to be torn down because it was degrading. This discussion about corporate welfare for hotel brands and for big oil, yes, if you're selling gasoline, you're participating in the petroleum industry, but those stations aren't operated by the oil companies anymore. That happened in the 50s and 60s. Now, those things are operated by local licensees for whatever name that is, and they hire local people to do those things. Hilton doesn't run any hotels. Hilton sells their name to hotels. There may be a few still that are run by Hilton. Those are local businesses or regional businesses that invest in hospitality, something that we are in deficit for because of growth in the Rantoul sports complexes, the growth of the University of Illinois, and the need for housing when people come to visit and people are coming to the community. Those are things that are deficit. Those are opportunity for bringing revenue in. You know, a truck is going through on 74 is going to get gas somewhere. It's going to get it at, right now, it's going to probably get it at Oakwood, or it's going to get it at Leroy. And because there is not a station like that that serves that capabilities on 74 in that stretch. They could go up a little bit on I-57 to get something. They could go south on I-57 to get something. But that main thoroughfare is the opportunity for them to stop there and fill up their tank in Urbana, where they would contribute to giving us revenue to help us do some of the things we want to do for those people that need help with being housed, other circumstances. So I welcome the kind of input that Grace and Chris have talked about with regard to how we design this RFP to get the business that's going to work there, that's going to be economic viable, but contribute to the economic health of areas that we want to see. But not doing anything and leaving a former hotel location to continue to be farmed in the middle of an industrial complex next to a truck repair shop, by the way, it doesn't make sense to me. So that's why I'm going to support that. We have to invest to make economic development work. You cannot just wait for something to land. If you wait for something to land, you could be waiting a really long time, and that's not growth. And so, and we don't want to be raising taxes. We'd rather see expansion by economic development, growth in value, those kinds of methods. So that's why I'm going to support this.
I will relinquish the chair back to James.
All right. Any further discussion? Seeing no further discussion, we'll have a voice vote on this. The motion is to send it to City Council on the regular agenda for approval. All those in favor say aye.
Aye.
Aye. Those opposed say nay.
Nay.
All right, the ayes have it. Thank you, Olivia. Next up would be ordinance number 2025-12-036, an ordinance dissolving the special tax allocation fund and terminating the designation of the City of Urbana tax increment redevelopment project area known as TIF 4.
Similarly, I don't have a presentation tonight, but to offer a brief summary, in accordance with the TIF Act, which is the state law that governs TIF districts, this is a formal ordinance to close out TIF 4, the very TIF that we were just talking about, effective December 31st, 2025.
All right, do we have questions? Yes, Grace.
Thank you. So this is to close it and transfer remaining funds by December 31st, is what I'm reading in section 5 of the ordinance, right?
So, yes, that is correct. But I just want to be clear that there will be a budget amendment that will follow to get that TIF fund to zero balance, and that'll probably happen in early 2026. The reason being is because there are still some active administrative accounting things that take place that we won't know the exact, dollar and cent amount to send to Central TIF until after that closes. So I just want to make sure the council is totally clear on that. This is the intent, but there will be some administrative action that would follow early in the new year.
Thank you, which I appreciate, because that was going to be a question of if we knew how much would be transferred. And I'm trying to remember, because I thought we already did, was it a budget amendment or authorization to transfer from TIF 4 to Central TIF, and we already did that.
Yeah, so the council approved budget amendment 4 in in late November, which transferred about $7 million to Central TIF. And those were dollars or monies that were not attributed to any open purchase orders or contracts. And so we could just go ahead and move that because it wasn't committed to anything. And then that budget amendment number 4 also created the line to tee up the purchase, if the council were to choose to move forward with the purchase and sale of that property. It created a budget line for that. So that
Your call has exceeded the maximum permitted duration.
Oh, sad.
so so I hope that answers your question. I'm happy to continue clarifying as needed.
Okay, thank you. And if I see if I remember my other question. Oh, no. Yeah, I think just I'll look forward to how much is actually there. And, oh yeah, other question was notice to the other taxing bodies. Could you remind me, I think we've said this before, but they were all okay with transferring, right? None of them wanted their money back, even the school district?
Yeah, we didn't. We've had meetings with the taxing bodies over the course. Actually, those meetings started before my appointment. And then we sent the letters notifying all the districts of the closure, and I believe the memo mentions it's an October date, and we received no comments back from any of the taxing bodies.
Thank you.
I just want to check. Chris, are you still there? We may need to reestablish the call.
He's probably calling back in, though.
No, but the call was ended because it exceeded its length. So we need to make sure our team back there is restarting it. We're going to take a brief pause here until we get Mr. Evans back on the line.
Taking a real recess?
Yeah, we're going to take a 5-minute recess. Okay. Going to call us back to order. Chris, are you there?
I am.
I may have shorted us a minute, I don't know, but it felt like 5 minutes to me, so. All right, we were in questions about ordinance 2025-12-036. Chris, did you have any questions?
No, not about this, no.
Okay. Are there any other questions? All right, can we have a motion?
I'd like to move. Oh. I guess you got to call on me.
Go ahead, Therese.
I'd like to move for ordinance number 2025-12-036, an ordinance dissolving the special tax allocation fund and terminating the designation of the City of Urbana tax increment redevelopment project area, TIF 4. Move that to, I guess, regular agenda.
For approval?
For approval.
I'll second.
Seconded by Mary Alice. Discussion. Grace.
Just say that I personally support the use of these funds in Central TIF for things like affordable housing in downtown once they're in the Central TIF, and acknowledging that they are from TIF 4 and left over, and especially if we do not end up prioritizing things like housing or community spaces for this TIF 4 property, I would definitely like to see that in Central TIF, which might be even a more appropriate central location for those sorts of things. But for, in my mind, the millions of dollars that we're moving from TIF 4 to Central TIF, in my mind, still need to be flagged for some kind of greater community purpose or serving the most vulnerable in our community.
Thank you. Any other discussion? Chris, are you okay?
Yeah, no discussion at this time.
All right, so we're moving this to City Council on the regular agenda for approval. All those in favor say aye.
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 Any opposed say nay. That passes unanimously. We're moving on to resolution number 2025-12-091R, a resolution approving and authorizing the execution of an amendment to a grant agreement for the fiscal year 23 Safe Streets and Roads for All grant between the Champaign County Regional Planning Commission and the City of Urbana. Thank you, John.
Okay. Well, good evening, Council. So I'm just going to pull up a couple of visuals for us here. So yes, we're coming back to talk about the Lincoln Avenue, North Lincoln Avenue corridor project. We have a grant that we've talked about a couple of times with you with Safe Streets for All. In fact, we came back to you in February, earlier this year, with the original grant agreement. And this is for, part of it is that the city will be leading a demonstration of the new configuration on Lincoln Avenue as a temporary demonstration, and that's what this grant would help fund. We're coming back to you because the original grant agreement had within it as part of its term, it would be a phased grant. So the larger grant is funding an update to the regional safety plan by the Regional Planning Commission. And we were in the planning phase for this demonstration project, and once we got that to a environmental clearance or environmental approval by the DOT, then we would come back with an amendment to the grant, because then they'd be ready to obligate the funds. So that's the administratively why we're here again to talk about this grant, because that was baked in the original agreement that there'd be a checkpoint at this point. So most of the terms of this amendment are really much the same of what it was before in the original agreement. Differences are we are obligating $160,000 for the demonstration project, whereas the original agreement only obligated the $785,000 for RPC's safety action plan, and includes minor updates to the grant timelines, and also includes a special grant term 6.9, which I explain in some detail in the memo. This is the similar in conversations we've been having previously, where this was essentially talking about immigration enforcement on the one hand, and then the next paragraph talking about how there's a preliminary injunction from a California v. Duffy case that essentially nullifies that executive order to comply. What was it? To cooperate with and not impede U.S. Immigration and Customs enforcement. And so then what has happened, even since we drafted this memo for the December 1st meeting, was the U.S. DOT issued this letter that I shared with you by email. I'm showing on the screen here, sharing that this preliminary injunction has turned into a final decision from the court, that the immigration enforcement condition, as it's termed here, has been declared unlawful and ordered vacated from all grant agreements administered by the defendants, including the Department of Transportation. And so, and my understanding from Federal Highways, from DOT, is that we'll get an updated, when we get the final draft of this grant agreement amendment, this entire section that talks about immigration enforcement will be removed. And so it won't even be a mention of this special grant term 6.9 in the final version of the agreement. And I'm talking about a draft of an amendment, a final version. Why are we bringing a draft to you? The reason we're bringing a draft to you is because to implement this demonstration of the, one lane in each direction and a shared turn lane on North Lincoln Avenue, and this is going from Washer Avenue up to Killarney, south of the interstate. We want to catch this in a good time in the spring. I want to get this new pavement markings put on the road by approximately around spring break, mid-March. And to do that, we need to go out for bids by the end of January. And so we're talking about, we just have a bit of a tight timeline here. to get this. We can't go to bid until this amendment is executed fully by all parties. So bringing this draft to you with the understanding from our FHWA contacts that we don't anticipate substantial changes from it outside of the change that I just discussed with you about the immigration enforcement condition. Now, the important thing is that this resolution that's before you is to approve and authorize the execution of this agreement, by the mayor, giving him the authority to do this. But the point is that it's substantially in the form that you see it today, and that I know that Matt Rushley is the city attorney and myself. It's our duty to make sure that what we advise the mayor to sign is not substantially different from what you see here today. So I just wanted to say that out loud. And if it is, then we would come back to you to have more discussion about it. So our hope is that we could ask council for an approval of this amendment in December, and then be prepared we should expect to get the final draft before January, and then we'd be in a position to get it executed and get the project out to bid in time for this demonstration. So I went a little longer than I expected to. I'm sorry, I know it's been a long night. But that is it in a nutshell. And so any questions?
What are the questions? Grace.
So there's, in the attachments, there's agreements from 2024 and 2023, right? I was confused if that was like a markup and a clean version, but those are different year applications. Is that right?
Yeah, so to step through kind of the attachments, what I've given is the amendment to the grant agreement. And so we're a subrecipient. Regional Planning Commission, they are the primary recipient of the grant. So we'll sign a subrecipient agreement with RPC, and then our subrecipient agreement with them has the parent agreement, I guess you'd say, between DOT and RPC as an attachment. So at the risk of being a little confusing, I've included both the amendment and between us and RPC, and the amendment between DOT and RPC, then the original agreement between us and RPC, along with the original agreement between DOT and RPC.
Thank you. Makes sense why it was a little confusing.
Yeah, I don't think I made it better, sorry.
That's okay. That helped. And then just as far as the actual wording of this ordinance, it says that we enter into the attached amendments for the grant agreement, and the mayor is authorized to take those steps, whatnot. Do we need to say something about like that it's in draft form or substantially similar to this? Like, are we good even if it says the attached amendment to the grant agreement if there are changes after our approval tonight?
I think, Matt, I'm, open to this too. It's like I've seen other language of resolutions that will say it more explicitly, like, the terms of the amendment to the grant agreement are hereby approved, but it kind of says it in longer language of like in substantially the same form as the attached documents, something like that. I think that if we said it more explicitly, like the resolution is passed for this potential draft, I think that's something we could add to that language.
Sure. I think that would make sense if that's what we are saying. I don't know, legally if that's something we need to do or is of good practice to do. But maybe to think about and consider for the final vote next week.
Mm-hmm. All right, thank you, Grace. Mary Alice?
So I'm wondering if this can be addressed with similar language that we do when we're approving something from the Plan Commission, that nothing substantially will deviate from this plan. If we could add in some kind of language that there will be only, I don't know if the phrase is de minimis, but any small changes, but any large ones would have to come back to City Council. I'd let the lawyer figure out what that language should say.
Mm-hmm.
Yep, I think we can craft something that captures that in spirit. So.
Okay, other questions? Chris?
No.
So I have a question. I think this is about the third time we've talked about this, and each time we've kind of asked that this be a test done in the fall when we would see the impact of like a football game day. Now here we are back going to do it in April. How long is it going to run in April?
Yeah. Well, Justin's not just a pretty face. Do you want to explain this to Justin?
Yeah, so we talked about this earlier this year. Our intention was to do this in the fall, not only to capture, the concerns about some of those heavier traffic days, but also to help with our project timeline. Due to just the process of this phase of the design and the environmental clearances that had to be passed through the federal government and all the delays we've kind of experienced. And then this agreement kind of being in limbo here until recently, we obviously missed that window. So in order to keep this project on schedule, our next window is in the spring once we get some hopefully decent weather and the opportunity to still capture traffic that represents, having students here, that population and some of the housing developments up that way. And then being able to, so we would do the demonstration from approximately spring break, so mid-March through mid-June. 90 days, 3 months is the window we're looking at. That actually will complete phase one of this design, and that's the last thing we need to do in addition to, and that will include public input. So we'll do a pretty substantial public engagement process at the same time as the demonstration, and then wrap that all up in June, which would put us in good position then to move forward with the next phase of design for the project. Shortly after that, which then keeps us on track to spend this money that we show in our budget being available as soon as FY28. So we pushing it back, if we were to try to do this in the fall of next year, runs the risk of delaying the project for another 6 months to a year, and us potentially missing the window for the STBG money that would be available for this project.
Yeah, but you're going to capture like Mom's Day and graduation weekend, which are pretty, because those are in April and second weekend in May. So you'll get to, those are, just to know that there's going to be at least a couple of high volume weekends associated with university is what I was that's why I wanted to know the span was.
Right, we're trying to capture,
like March 15th to April 15th. I'd say that's not going to tell you what the impact's going to be on those high volume.
Right, we're trying
if it's
to capture,
going to run into June, I'm comfortable with that.
Okay, we're trying to capture that warm weather with the student population in town. Okay. And our hope was to do it in the fall, and like Justin said, because we had to get environmental clearances for putting paint on pavement. That we, and the grant agreement going along, we missed that opportunity, and so this is kind of our next best chance. So. All
right. Any final questions before I have a motion? Who's going to make the motion?
I'll make a motion. You know what? I'm going to make a motion to put it on the consent agenda. Resolution number 2025-12091, 091R. Resolution approving and authorizing the execution of an amendment to a grant agreement for the fiscal year 23 Safe Streets and Roads for All grant between Champaign County Regional Planning Commission and the City of Urbana.
Second.
All right, it's been moved and seconded. Any discussion? Yes, Grace.
Just something we can come back to next week, but that we did have some potential changes to the language, just as far as putting it on consent, but we can burn that bridge when we get to it. Thanks.
Yes, if it's not sufficient, we can pull it off of consent. All right. Chris, any discussion?
No.
All right. All those in favor say aye.
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 Any opposed say nay. That passes unanimously. You guys are going to stick around for the next one too, right? Resolution number 2025-12-092R, resolution approving and authorizing execution of a license agreement with Urbana School District number 116 for on-street parking and a bus turnout at 1602 South Anderson, which is the Flossie Wiley campus of the 6th grade center.
Thank you, James. And you probably noticed that I specifically was just calling it by its address. Didn't know what the name was going to be.
I did notice that.
Yeah. So we do, but it's not bad practice. It's a clarification, for legal documents like this. But yeah, for the Flossie Wiley campus, as you're all aware, the school district went to, had a great project improving this campus and expanding the building. And as we were getting into reviewing the development from the city side, we had conversations with the school district just kind of about cleaning up the way that the right-of-way is being used, has been used for years, and the addition of this bus turnout that was built on Florida Avenue. So the way that parking works on this campus, and of course this aerial image that I'm showing is of the old campus, the old configuration. But as far as I can tell from probably dating back to the 1950s when this school was originally built, there's been street parking on Pennsylvania Avenue and Anderson Street, and it's been in this configuration where you're basically pulling perpendicular into the parking lanes, and so when you have to get out, you back out into traffic. It's not a configuration we would want to see today, wouldn't allow today, but it's been in effect for so long that we just wanted to essentially formalize this arrangement in the license agreement. The school district has been clearing this of snow and sweeping it, for this time. It's kind of the informal arrangement. This license agreement also just formalizes that. And as another step just to kind of dot our I's and cross our T's, the school district will apply for a zoning ordinance variance for the way this parking configuration is on Pennsylvania and Anderson there. Then they also added the bus turnout and kind of helped with the distribution of kids to and from the middle school and high school campus to the 6th grade center, all that. And I think it sounds like it's been going pretty well so far. And so they just built a bus turnout off of Florida Avenue there within the right-of-way. And the school district will be responsible for, maintaining that pavement and replacing it as it needs it, but the city will be plowing snow off of it. So we just kind of a practical arrangement with the school district about that. So those are kind of that's the meat and potatoes of it. It's not signed yet by the school district, but no, Dr. Ivory Tatum was comfortable with it and just asked that we go ahead and look for council's approval.
All right, questions? Yes, Grace.
Thank you. On Florida, is there already a bus turnout lane there?
So this is let me see if I can zoom in a little better. So yeah, this is an aerial image from before the improvements, and I do have that drawing, don't I? So there's the 2 lanes of traffic, there's a bike lane, and then there's the bus turnout on the other side of the bike lane, before the sidewalk.
Those aren't parking spaces. That's just the bus turnout.
Correct. Yeah, that is just the bus turnout. Don't know if this will help or not.
And my kind of the root of the question was about the bike lane and kind of how that works with crossing the bike lane.
Yes, and in short, yeah, I mean the buses will have to cross the bike lane to get into the bus turnout. Yeah.
MTD and school buses?
Well, the MTD is acting as the school bus for this, and so I believe the yellow buses they go into the campus, where this is just MTD buses.
Yeah, the yellow buses use that loop on the east side of the building, which is on the top of the page here, and the bus turnout has already been constructed. It was done as part of the construction project for the school.
Thank you. And then the angle of some of the parking spaces, it looks like it's, really oriented for one directional flow of traffic. Like if you were coming south on Anderson, you'd have to flip around for that angle, or if you wanted to head back down south, you're at an awkward thing. And those aren't necessarily one-way streets, but it looks like we've designed it for a one-way flow of traffic with the angles, right?
Well, I would say that's true on Pennsylvania. Pennsylvania, and I'm sorry because the last two images I showed you, north was in different directions, but north is up. So Pennsylvania does have the angled parking, sharply angled. So you'd have to be going eastbound to safely go in and out of those spaces. On Anderson, it is perpendicular, so the direction doesn't matter, but the school district does.
Oh, you're keeping them that way. Those purple dashed lines are not the new
yes.
orientation of the parking spots, or are they?
That's a hatch block. Yeah, that's a hatch pattern. Sorry. Yep.
Okay, but on Pennsylvania, they are. Oh no, I see the white. No, just kidding. That's the real
Yeah.
one. So that's not changing. The orientation of the
Yep.
existing parking spots is not changing.
Yeah, pay attention to the white. That's right. Yeah.
Okay. Sorry, yeah, I was confused with the purple there. Okay.
I see it.
Cool.
I
Thank
see
you.
it. Yeah, because that would be like counter to how they have the one way going to as right now as well.
So is Anderson was one way during beginning of school and after school for a while. Is it no longer one way during that period?
So yes, I think it was when it was Wiley Elementary School, and then when the school wasn't used for a year, there hasn't been any traffic control. And then with the development of the redevelopment of the site, the school district has adopted a new traffic plan that they're, I'd say, working through or testing in this first semester, which is to close Anderson Street at Florida and run traffic south down Anderson, but then back up north. So they've added, if you could pull up the site.
Oh, there's
plan,
the drop off.
They've added a drop off loop on the west side, so off of Anderson. So vehicles can come south down Anderson, go through that drive through, and then exit to the north.
Okay, so they're just blocking Anderson off at
Florida.
At Florida, okay.
Yep.
Thank you.
Yep.
Any other questions? Yes, Grace?
I'm sorry, I couldn't find in there. Is this the new adult education center? You said it's not a school?
No, it's the sixth grade center.
Oh, it is the sixth grade center. Okay, thanks.
All right, could I have a motion?
I'd like to move for resolution number 2025-12-092R, a resolution approving and authorizing the execution of a license agreement with Urbana School District 116 on-street parking and a bus turnout at 1602 South Anderson. Move to consent agenda for approval.
Okay, it's been moved and seconded. Any discussion? Chris, any discussion?
No.
All right, all those in favor say aye.
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 Any opposed say nay. That passes unanimously. Thank you. You guys here for the last one too?
Yeah.
Resolution number 2025-12-093R, a resolution for improvement under the Illinois Highway Code, state motor fuel tax for Vine Street and Washington Street.
Okay, thank you. And like when we talked about maybe a month ago or so, we're cleaning up our books with IDOT, just making sure that our MFT funds are all accounted for in the right way. We have this particular project, Vine Street and Washington Street, which was rebuilt back in 2020. We just had an administrative miss on this. There was just under $50,000 spent on design engineering that didn't get an MFT resolution through council. So there was not that paperwork, that step in the process. And so we're coming back to see if we can get that rectified. And because if we don't, we don't have to, give the state money back, but what we'd have to do is we'd have to get money from another account and move it over to the MFT account. If council be willing to ask for an MFT resolution on it's just a 5-year-old project, that's not too old, for $50,000.
All right, what are your questions? Chris, any questions? There's none in the room so far.
No. No.
Yes.
I'd like to make a motion for resolution number 2025-12-093R, resolution for improvement under the Illinois Highway Code, state motor fuel tax for Vine Street and Washington Street to consent agenda for approval.
All right, it's been moved and seconded. Is there any discussion? Chris, any discussion?
No.
All right. Let's go ahead and vote. All those in favor say aye.
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 Any opposed say nay. That passes unanimously. All right, thank you, gentlemen. And now we are in the discussion section of our agenda, and we can use this opportunity to go into any updates based on, we have a version 7.2, I believe, of the proposal. Grace, would you like to give us some
What's that?
updates?
If I may pull up the materials.
That would be great. Thank you. You guys aren't going to stay around for this? It'll be riveting. We're getting really close. You might see the end.
And just some quick summary of the materials that were already sent out. There's a version 7.2. There's a markup that was shared with you if you'd like to see all the few changes between 7.2 and 7.1 that James and Mary Alice had worked on. And then there's a clean version that's in the packet. There's also updated surveillance definition comparisons, and this might be helpful to explain some of the changes or coloring. So we've seen this list before. These ones that have a yellow background are ones that are new or changed, and then I highlighted the changed wording. This GPS tracking systems was already one in our proposed ordinance definitions. I had just overlooked it when I was putting it in this Excel sheet, so that's just updated. And then I do have some new proposed language of talking about GPS tracking systems in accordance with Illinois Freedom from Location Surveillance Act. This top one about video monitoring was already there with some added proposed languages about technology that can be remotely accessed, which is in line with many other cities' ordinances. And then for consideration, including privately owned devices such as doorbell cameras was something that we had talked about incorporating. And since a lot of these definitions already say any video or audio monitoring that can be transmitted remotely, that seems to classify under that definition. And I would think that it's important to just kind of lay that out. And then this one of drone usage in accordance with the Freedom from Drone Surveillance Act. Then some of the colors below, I was thinking the ones up top, closer to the top, are more in similar citing with other ordinances from other cities. And then down below, there are ones that are less common, so I think that we could argue of removing them or combining them. I kind of had them color-coded by things that could potentially be combined just to simplify it. Things like the scanners and radio stuff in blue and purple about through the wall and x-ray things being somewhat similar. And then in red, I don't think that we have electronic toll readers, so not as relevant, and DNA capture technology would be covered under any biometric surveillance technology. So I think those could be argued to be removed. And that's about the main updates there. You can see in the other general definitions from the other cities where it talks about things like each of these does talk about location being one of the definitions of surveillance. And so that's why it might make sense to just have that as a specific example definition. And then there are no changes from the last time you saw these notes about things that were not covered, and we still may want to consider adding a few things that are in other cities' ordinances and not ours. And I'd say between 7.1 and 7.2, there were not, I'd say, many significant changes. I don't know if there was guess it's subjective to call it significant, but a lot of these are even between 7 and 7.1 that James and Mary Alice had already changed. We had already gone through that. I think that we had a pretty good agreement / clear areas of still disagreement on 7.1 versus 7.7 versus 7.1. And then I think here in blue is actually the changes from 7.1 to 7.2. And again, this was attached in emails to council as well. There were some changes that we had talked about in our previous discussion, like we had talked about and in a straw poll, I believe, on things like public input period of 30 days and just combining some of those sections. So I'd say, I think almost all, if not all of these are ones that we had already talked about in previous discussions and straw polls. I'll be taking any other thoughts or questions.
If you don't mind, if we could start back up towards the top where there's, I think we had gotten pretty deep into this. We had gotten down to around section 7, I think, where we started to get bogged down when Jaya was leading us through this. There are a couple of changes here that are prior to that. So if we could talk briefly about this change to section 2A, which has now additional language.
So the changes in red are from 7 to 7.1 that you and Mary Alice had
Right,
done.
I'm talking about
And
this,
then in blue.
the change in blue.
Yep, so it's
about adding data from a new source or new analytical tools in a manner which changes the functionality of existing data collected by the surveillance technology. So this is new language that you and Mary Alice added in here?
No, it is reworded language that has already been in there.
Okay.
You can see below where it's struck through, that was the previous language.
And so okay, I understand that now. Since you and Mary Alice put this together, I would ask if Chris and Charisse have seen that and you're okay with that change?
I'm okay with it.
Okay. I'm okay with it too. I just want to make sure that we're touching any of the things that have changed in the area that we moved through before, even if it's an improvement. And so I think 2B there, that additional language is just clarification that's the intent of that is to give the public time to provide feedback instead of having a separate bullet for that. Is that correct?
Yes, we had talked in discussion about removing C and combining it with B since
So that's the outcome of our previous
Yes.
discussion? Okay.
Yep.
If you could keep on going down then. I think all of this has been addressed.
This was just small numbers about referencing different sections of the
Okay,
ordinance.
yeah, just keeping that correct. So this item C here, seems to be a new bullet
That is new, yes.
that's been added. And Mary Alice?
I believe we didn't talk about this. I mean, no, let me restate that. We did talk about it, but I didn't come to any conclusion. Am I remembering our conversation, Grace? I think your rationale for this was because any two members, council members, could bring anything to city council anyway. I think that's what you were referencing. Is that right?
Yes, and I do apologize. This was one that I think, yes, was not talked about in the group discussion, so thank you for pointing that one out. This was confusing it. It was discussed in a 2x2 with Mary Alice and myself and city leadership and attorney, I believe. And yes, Mary Alice said, since any two council members can bring something to the agenda, this is just clarifying that process, that this is the same, so that there's no question about reevaluating something, because that, as it's written without this, once something is approved, it's indefinite, and there's no process for reevaluating it.
So here's my challenge with that. If it's already covered under the existing way we do things, duplicating it here means that if we address our rules and talk about our rules at some point and we change that, then we have to go back and find all the places that like restates that thing that we already agree is that way. And that worries me.
Yeah, that is, I think, a legitimate practical concern. The other thing I would point out, unless I'm mistaken about this, is that this rule is presently a council rule and not part of the city code. Am I incorrect? Okay.
It is codified in our city code, the process by which items are placed on the agenda. So it is not just a council rule, it is binding.
So disregard that.
Mary?
I'm just wondering if in order to ensure that it is consistent with whatever rules we have in place, if we reference that. So council members may request that surveillance technology be reevaluated according to the rules in the city council rules for bringing something to the agenda. If we could just reference that, I think that kind of clears that up a little bit. And we don't have to go back every time we change that rule to also update this.
That would eliminate my concern. Grace, if that's okay with you.
I don't know. May need to think on that because different things. I mean, I don't agree with upping the bar so that it takes more than 2 council people, but I guess that's the thing for the majority of council to vote on and decide.
Yeah, I think that's going to be an item that's going to come up when we address council rules, and I think we're pretty even on how we feel about that, so it could go either way.
Well,
Could you state what it means to have surveillance technology be reevaluated? Who does the reevaluating? We do?
Council.
Or
Yes.
the police department does? So reevaluated in what way? Like, does it work? Do we still want it? What do you mean?
yes, maybe reconsidered would be a better word. And so for approval would be by city council.
Be reconsidered.
And so when we do this approval, what is the policy behind the approval after that? Meaning, I guess that's what I'm trying to understand.
It would be the same as the first time it were approved, outlined in section 2 and 3 of the ordinance.
Okay, but what I'm asking is when we approve it, are we discussing this particular thing the way that we are discussing it now? Or is it, I mean, and when I say that, I mean like all open meeting and everybody's talking about what the surveillance stuff is going to be and how it's going to be used and where and under what circumstances, and is there a case number applied to it or any of that?
So it would be the same as the new one. So it would be brought to council and made publicly available, the use policy and use report. There would be a 30-day input period, and then there would be a vote for approval by a majority of council. And we would use these standards for approval, just like the first time something were approved.
I guess I don't know. Okay.
So now that Charisse has put it that way, I guess I would, I don't know that we're going to come to a firm conclusion on this because of the 2 or just use the current council rules for this. But I would ask that we consider putting a higher bar in here for making this request. In other words, the technology has been evaluated. There's been a process. I would suggest that the council members that want it to be reevaluated would have to describe the circumstances that have changed that would justify us going through that process again, as opposed to 2 people who didn't like that we approved it constantly coming back and asking for it to be reapproved. What's the purpose for reevaluating it? Is it, and this is why I'm concerned about our current council rules, and we're going to talk about this more, is that, you know, we should not be in a place where we create a process that doesn't require people to state the purpose for why they're asking us to go through this kind of administrative process over and over again. Okay, so maybe not quite resolved on that one yet. Let's keep going down and see what else is here.
I will also remind us that by my watch, it is 10:16, and prior to 10:30, we would have to take some sort of action if there was a desire. You don't have to do anything right this second, but just awareness.
As chair, I'm going to say that because we started at 6:30 with township, those rules are there to keep us from working beyond fatigue, and I am not looking to entertain a motion to extend tonight. But I do think we can get a little bit deeper in this. Do individuals have additional council input and communications for tonight that we need to be aware of? Grace, did you have anything else to share? Chris, did you have anything else to share for council input?
No.
Okay, then we'll focus on this, and when we get close to the end, we'll just end. Okay. Okay, so this C item, you guys took a stab at rewording this.
We did. I was going to check, or is this the attorney's language? I'm getting a little lost myself. I apologize on some of the updates. We did have recommended language from city attorney that I thought I put in there. We can check if this is his wording or our best
I guess
attempt.
I'm okay with putting wording in there that we have to put in there, but I would like to make sure that there's wording in there that the public can parse very simply. And I think what I asked for previously was that this state very early that we don't want the mayor or the city selling data. And then this additional explanation of what that looks like.
Yes,
I'm
so
fine
that
with
is
that
moved
being
up.
in there for legal reasons, but I wish it would just say at the beginning, you know, we don't want you selling the data, and here's the legalese that we think will prevent that. Yes, Mary Alice?
Yeah, I mean, if you'll see the comment that Grace had put in, this is like, the basic intent is the city won't sell surveillance. So we could even say, the city is hereby prohibited from entering into any contract or agreement to sell data. Like, you know, that's something that's very busy, you know, very simple.
This means
Yeah.
the extra stuff.
I completely agree, and I guess I would ask the city attorney, is there, what additional language needs to be included by basically saying the city may not sell data? What beyond that needs to be in that paragraph?
I can take a closer look. There's a lot there, potential factors to consider. This is not,
Not your
looking
version.
at what I sent, I don't think this is what I generated, but
Thank you.
I'll confirm that.
Then I would propose we maybe loop around to that one, and I will check with getting the updated language. But that's why, yeah, Mary Alice and I at least moved that, not selling it in exchange for monetary forms earlier, and Matt had some other suggested language that was sent out to everyone that we can maybe revisit that. This was just a small piece on the patches or upgrades that we just added that are necessary to maintain essential operations or mitigate cybersecurity threats based on Mary Alice's input, that it might not be just for cybersecurity. I think we talked about that as a group, but I don't recall. This was just clarifying about voluntarily offering, not voluntarily offering ill-begotten surveillance data for criminal prosecution.
Grace, can I stop you for a second? So I think one of the questions that we had was, if you scroll down just a little bit more, it basically says, unless it helps with somebody's defense. And I guess the concern there would be is, how would we know that it would help with somebody's defense if we destroyed it? Like, so the timing issue is potentially something we should address. But just for conversation.
Yes.
Yeah, that was my concern about the.
Yep, you're right. It
The
was your
B
concern.
is how do you, without an active discovery going on, how would you know that it could potentially be in the future helpful for defense? Once it's gone, that's not an option, correct?
Yeah, if it was deleted or destroyed, I don't think there's a way of retrieving it. I mean, we would destroy it in the same manner we do with other city records. Likely, there would be some requirement to retain it for some minimum period of time under the Records Act, but exactly what that is, I think, will depend on the nature of the information.
Yeah, I would be concerned that, data could be destroyed in an accelerated manner because it could be utilized in defense if we didn't keep it for, if we didn't have a set timeline that it was kept for before this happened, it could be arbitrary.
I was just going to say, it seems to me that digital data, because it degrades after a while, maybe there should be something that says, because like you said, you don't know what's for defense. You don't know, somebody may if they're incarcerated and it's found out that there's some other stuff, it would probably behoove us, if we're going to be adding rules about stuff that we don't really know about, you might want to just make sure you get a hard copy of everything, whether it be pictures, whether it be verbiage, whether it be whatever files or something, that everything would have to be kept in a hard copy. And then we're not held responsible for that. That falls to the court system to hold those kinds of that kind of data for however long. Example is that, like, murder has no statute of limitations. I don't know what the statute of limitations for something else like theft or rape or so on and so forth would be. But if we find out that a person's, license plate or just the wrong car, the wrong model or something like that, was made a difference in their being found guilty or not guilty, and the police department they're the ones doing the evidence finding. Yeah, I would think you'd want to keep that somewhere in a hard copy.
I don't think that's the practice anymore.
I think that would be the practical practice, since, like I said, digital stuff does degrade.
I'm not sure what you're talking about, Sharice.
So if
Okay.
I feel like, Sharice, maybe I can expand on this. So I feel like a video or a still picture would be something that could be printed, right? And so I think your concern would be, which is actually a little bit opposite of this, that electronic files can, quote unquote, disappear. I'm going to just say disappear for lack of a better word, and it's 10:24. So what I'm hearing you say is that data that is collected by surveillance technology that doesn't agree with this ordinance, you're concerned with electronic information disappearing could be addressed by actual hard copies of the information. Is that correct?
Right.
Okay.
Paper copies of some sort, photos, whatever, print it out and keep it. And that would become the responsibility of records someplace else, and Darcy's saying no.
May I clarify here too that at least Section 7 is only talking about information from surveillance technology that was not allowable, that's in contravention to this ordinance. So this is only talking about if, say, we used drones without approval from drones, or it was outside of the policy, or whatever it may be. This is only for if we're using surveillance technology that is not in line with this ordinance. If we're talking about the ones that are, that's going to be a separate record-keeping system that I think we're going to have to get into with each individual thing, and there's already processes to do that.
Okay. Whatever.
Okay, and then the next thing that I think is going to take a longer discussion is about the role of the CPRB in this, which I don't think we're going to be able to resolve tonight.
Correct. But if I may highlight that we got a review of those ordinances from our city attorney and I think that went out to everyone. So for your consideration, and also I think it would be great to hear from the boards themselves. We had the CPRB chair, but I think if we're going to talk about making decisions for those boards, it would be great to include them.
I'm gonna say this out loud. Since the board chair for the CPRB has been working a lot on creating this, I think he's got a bias in this. I think he's creating more of a role for the area that he controls and wants to have more effect there. And so, you know, I know he's doing this with the best of intentions, but I don't want to have this conversation without acknowledging that this is trying to pull more things into that span of control. And we have to make sure that that's not being done for that kind of reason.
You're entitled to your opinion. I disagree. I don't think that's how this worked. Remember that this section was added later on, maybe 7 months after the first version was proposed that Tony had helped draft. So being someone who has worked on this for over a year and knowing mine and Tony's involvement, I would say that is not the case. He helped draft all of this without any part of CPRB being in place. I added this section based on best practices from ACLU that they recommended that there was oversight, and CPRB and HRC seem to be the appropriate commissions. So I appreciate the optics of that, and you're entitled to your opinion, but I will say, in my opinion, that's absolutely not the case, and based on the timeline of how these things happened, I think that's not the case at all.
Yes, Mary Alice?
One option that I think we should consider is changing the word from shall to may. So the Civilian Police Review Board may review each surveillance technology, and it just, and Grace and I didn't come to an agreement on this because one of the things that I was trying to alleviate here was the workload of CPRB, but also the fact of trying to figure out how that review would be handled at the city level. So the may gives them potentially the opportunity to do it, but it doesn't mandate it.
And that's going to have to be the last word, because
Yep.
we have run out of time.
10:28.
And we will continue this discussion can we have some time for this on the city council agenda as well? Make progress? All right. Thank you very much. We are adjourned.
Okay, I was just going to say thank you, Grace.